Breaking news tonight. The Supreme Court has just taken a major step that could block the ATF's short-barreled rifle restrictions nationwide. This could dismantle parts of the NFA as we know it and impact millions of law-abiding gun owners. Let's break down exactly what's happening, why this matters, and what could come next. This all began when the ATF introduced new rules targeting short-barreled rifles, or SBRS, under the National Firearms Act. Several states and gun rights groups immediately challenged it, calling it unconstitutional. Those cases have now reached the highest court in the land, and what happens next could change everything we thought we knew about federal gun regulations. To understand why this is such a massive deal, we need to talk about what the SBR and NFA rule actually means. Under the National Firearms Act, any rifle with a barrel shorter than 16 inches is heavily regulated. You need registration, tax stamps, and federal approval just to own one legally. The ATF's recent reinterpretation expanded that definition, sweeping in millions of AR-15-style pistols equipped with stabilizing braces overnight. Accessories that were perfectly legal became potential felonies in the eyes of the federal government. Now, here's why this rule caused such outrage across the gun community and beyond. Gun owners called it government overreach, claiming the ATF turned ordinary citizens into felons overnight. Without any new law being passed by Congress, lawsuits flooded in from Texas, Florida, and several Second Amendment advocacy groups nationwide. The Supreme Court has now agreed to hear arguments that could permanently block the rule, and the implications are staggering. So what exactly did the Supreme Court do? The court has decided to let the challenge move forward, refusing to dismiss it as the Department of Justice requested. That means the issue of short-barreled rifles and NFA enforcement is officially on the Supreme Court's radar. This isn't just a procedural step. This is the court signaling that the constitutional questions raised here are serious enough to warrant full consideration at the highest level. Let's talk about why this is a genuinely big deal for gun rights and federal regulatory power. If the court sides with the plaintiffs, we could see the entire SBR classification system overturned. That would mark one of the biggest rollbacks of federal gun restrictions in nearly a century. This could even open the door for larger NFA reform, potentially affecting suppressors, short-barreled shotguns, and other items that have been tightly regulated since the 1930s. The Department of Justice and the ATF aren't just sitting back and accepting this. The DOJ is scrambling to argue that the ATF acted within its authority and that the agency has the power to reinterpret existing laws to address modern firearms technology. However, multiple judges have already ruled that the agency overstepped by creating new laws without Congress. Now, the highest court in the nation will decide who's right, and their decision will set the standard for decades to come. To really understand the magnitude of this case, we need some historical context about the National Firearms Act and its legal challenges. The NFA has stood since 1934, passed in the wake of Prohibition-era gangster violence. But it's been challenged many times over the decades. In the past, the Supreme Court avoided taking direct aim at it, often dismissing cases on technical grounds or declining to hear them altogether. This may be the first time in decades the court re-examines the constitutional foundation of the NFA itself, and that's what makes legal scholars on both sides extremely nervous. Before this reached the Supreme Court, there was a clear split in how lower courts interpreted the ATF's authority. Some appellate courts sided with gun owners, calling the rule unlawful and beyond the agency's statutory authority. Others upheld the ATF's interpretation, arguing that the agency has broad discretion to regulate firearms. This split between circuits is exactly why the Supreme Court had to step in. When different parts of the country are operating under different legal standards on the same federal law, that's a recipe for chaos. Let's bring this back to the people actually affected by all of this legal wrangling. There are more than 10 million brace-equipped firearms in circulation across the United States. If the rule is overturned, those owners will no longer face registration requirements or criminal penalties for simply owning what they purchased legally. If the rule is upheld, non-compliance could mean severe federal charges, including felony convictions and years in prison. We're not talking about abstract legal theory here. We're talking about real Americans facing life-altering consequences based on how 9 justices interpret the Constitution. So, what are the possible outcomes when this case is finally decided? There are essentially 3 scenarios. First, a full repeal of the ATF rule, which would return us to the status quo before the regulation was announced. Second, a partial modification where the court might uphold some aspects while striking down others. And third, complete upholding of the ATF's authority, which would validate the agency's broad power to reinterpret existing laws. But with recent Second Amendment rulings like Bruen and Heller, the momentum appears to lean toward rollback rather than expansion of regulatory power. Speaking of Bruen and Heller, we absolutely need to connect this case to those major legal precedents. In the 2008 Heller decision and the 2022 Bruen decision, the court set a clear standard that any gun law must align with America's historical tradition of firearm regulation. The court made it crystal clear that the government can't just claim a regulation is for public safety. They have to prove it's consistent with how firearms were regulated when the Second Amendment was ratified and in the early years of our republic. The ATF rule on stabilizing braces fails that test, plain and simple, because there's obviously no historical analog to modern pistol braces in 1791. The political and public reactions to this Supreme Court move have been intense and predictable. Second Amendment advocates are celebrating this as the start of a nationwide rollback of unconstitutional gun control measures. Organizations like the Firearms Policy Coalition and Gun Owners of America are calling it a watershed moment. Gun control groups, however, warn it could flood the streets with unregistered weapons and make law enforcement's job harder. The debate is now reaching every level of government, from state legislatures to Congress, where some are already proposing legislation to codify or counter whatever the court decides. So what's next in this legal saga? The court will schedule oral arguments in the coming months, likely sometime in the next term. Until then, lower court injunctions remain in effect, blocking ATF enforcement in several states. That means in some parts of the country, the rule is essentially unenforceable right now, while in others, gun owners remain in legal limbo. This case could reshape firearm law for generations, affecting not just SBRS, but the entire regulatory framework around the National Firearms Act and how federal agencies can interpret and enforce gun laws. To sum it up, the Supreme Court has allowed one of the most important gun rights cases in modern history to move forward. If this ends with a nationwide block of the ATF's rule, it could fundamentally rewrite how the NFA is enforced and potentially open the door to challenges against other provisions that many Second Amendment advocates have long considered unconstitutional. Whether you're a gun owner, a legal scholar, or just someone who cares about how our government exercises power, this case deserves your attention. Stay tuned, hit that like button, and subscribe, because this fight for your Second Amendment rights is just getting started, and we'll be here to break down every development as it happens.